But we've got a great panel here to look at, to take us through aircraft repossessions. Chris, as you heard yesterday from First Source, has hardly ever had to repossess an aircraft in Brazil. Ricardo, I think, has worked on more than one or two in his time here. And David just likes anything that goes wrong.
I just love it.
Love it.
What we thought we'd do is we'd start with a hypothetical case. And just to make it clear, it is hypothetical. It has nothing to do with Chris. But you've closed a deal for a Brazilian owner 2 years ago. All through that time, the owner has been paying, no problems. You've inspected the aircraft, it's fine. But then you hear rumors. There's a couple of negative news stories about the owner's business. What would you do?
Well, first thing we do is want to communicate. So we contact the client, we ask them about the things that we have seen and heard, and we may ask for updated financials, we may ask for updated maintenance inspection reports, or may even ask for one of our approved inspectors to go and look at the aircraft and inspect it. But that's usually the first step, and usually we'll have a regular feeding of financials coming in quarterly, biannually, or annually, and so we'll have a feel for what's going on typically. But if there's a surprise and we know about it before the client notifies us, we want to open that dialogue first thing and start communication.
And Ricardo, are you digging out the file now and having a look?
Well, I would start building a case, let's say, because of possible future events. So as we know, the finance agreements and the lease agreements normally contain provisions where the debtor states that there are no known facts which could negatively, adversely affect assets, business, or financial conditions of debtor to perform under the agreement. And there are also provisions where they state that any material change in the financial capacity must be informed to the creditor. And there are not misrepresentations or failure to inform material changes are events of default. Of course, we will never recommend terminating the agreement under this basis at this stage, but perhaps sending a notice letter, more formally, to ask them to confirm whether this information on the press is correct and to confirm that there has been no material change in their economic capacity. I think that would be the first step.
And that's something you have to do quite diplomatically?
Yes, we have to do that very carefully, and we always want to do it with respect. There could be misinformation, and we always want to assume the positive.
David?
So we always assume the negative, because that's what we do as lawyers, right? So the fact of the matter is, rarely do borrowers, whether in distressed positions, do what they say they're going to do. I mean, Chris, you outlined exactly what banks and financial institutions should do. You should actively manage the client when their risk alerts pop up. Actively manage it. Be all over them, as long as the documents allow you to do that. But the fact of the matter is, once people start getting in trouble, they're going to start being very defensive. And that's the hard part for banks and lenders and lawyers.
I should have said that it's the second aircraft he's financed, so you know him, you've got a good relationship.
Yeah, and in the scenario that you present, it's a client that we know well. It's a large client. It's a multiple aircraft owner client. And given that relationship, we would want to work with them, especially since we were comfortable with them in a previous position years before, and there's a strong relationship assumed in the example. So we would, again, we want to be careful how we approach the information that we receive.
Okay. He's paid you, he's still paying you, but then you get a call from the engine program company going, he's 2 months late with us.
Yeah, so it used to work like that. I say we, in general, I'm going to be speaking as if I'm a neutral banker, not just from my company, but as a neutral banker. I have to give a disclaimer. I'm not as good at disclaimers as David is, but I'm going to give a disclaimer that I'm speaking as a generalized banker here. But most banks should have the aircraft engine program assigned at the close to them. So what should happen is that the financing institution would be notified of any lack of payment at the same time that the client is, so that there will be no need for the client to notify us of their failure to pay the engine program. In theory, this is how it should work. And so what has happened is the bank or the financial institution will receive this notice directly from Rolls or from whatever, and we have to contact the client and say, we've received this, can you help us understand what happened? And usually there's a missed check or some type of, especially on a long-term relationship where you have multiple years of ownership experience with the client that's a big company. There's some kind of accounting error or something that usually happens like that. It's not untypical. But we work through that, and if it becomes, the things that you want to look for as a financial institution to kind of back up a behavior are, usually it's multiple areas of smoke, not just one fire. So it may be, if you're tracking the airplane, maybe the airplane hasn't moved in 3 or 4 months. And then there's a notice from the engine program that they haven't paid. Those two together, that's something that we would want to really look into.
And Ricardo, presumably that is another event of default.
Absolutely. On a legal standpoint, in addition to what Christopher said, an overall analysis of the relationship with the client, payment history, and etc., I would consider first, has he responded to the first notice letter about the press? Has provided proper information about that or not? And perhaps the recommendation would be to notify them about the default under the maintenance program, providing a short deadline for them to respond or to cure the event, to cure the default. And if the default is not cured, if you had issues with payment history, even in other contracts, improper response from the first notice and not payment after the second notice letter, perhaps that could be an indication of liquidation problem or perhaps closer to an insolvency. Not that close, but perhaps that's something to consider. Depending on the circumstances, it could be possible or advisable to file, to consider that as a default, terminate the agreement, and try to repossess the aircraft. And just to put an idea, repossessing aircraft is always easier when there is a payment default, but we have situations where we got already repossession orders in situations of change of control. It was a case where the debtor, the shares of the company debtor were transferred to a third party without approval from the creditor, and that is an event of default. In this concrete situation I mentioned, we represented a client in court. The court accepted the termination, repossessed the aircraft, and the situation was resolved as is, even though there was no lack of payment, no default on payments, but another default like a maintenance issue, in case here was a change of control. So that's a possibility, not that it would be recommendable, depends on the overall situation, but that's an option on the table.
Again, you're at a hypothetical bank, mega bank, not First Source. Are you now, internally, starting to, warn people?
So is the next step, are we leaving off right where the engine program was filled? Okay, we're still there. So I think for there, we would not typically issue a notice of default upon receiving information that the engine payment has not been received, because we want to give time to cure. So we would notify the client, we provide time to cure. If the time to cure has expired, that's when we have more serious conversations, and then eventually we would issue what they call a notice of default, and that's a formal term to notify a client that they have failed to meet an obligation.
David?
Yeah, I mean, that's everything Chris said I agree with. It's just that the whole repossession process is so messy and it's awful. No bank lender wants to take back a plane, and it's so expensive. The first thing I would do is just, when you do your visit, scan all the maintenance records, because I don't know what it is. Anytime things go badly, maintenance records just disappear. They just disappear. I'm like, where are they? I don't know. They keep the records hidden. So scan the records and just ask if they're defaulting on their maintenance programs, what else are they defaulting on? Their management agreement, their fuel. All of these liens are going to cascade and just hit at once on the same day. And ask about other things that could trigger it. And Chris just mentioned it before the panel. Is the guarantor going through a divorce? Are there some external things you have to worry about? At these conferences, I always just ask other people, have you heard about this? What's going on? You know, what about, are they paying you? And so that's why it's good to just get as much information as you can, because information is power, and the more information you have, the better you're able to make a comprehensive plan to solve the problem.
Well, you brought up a good point, David, about liens. And that one thing that we might do in the background during this particular stage in the hypothetical with Megabank is that we would take a look at the liens, maybe do a title search, just to see if there is more smoke to be added to the fire.
And Ricardo, how easy is it to do that in Brazil?
We of course have been awarding repossession orders. In our experience, we never faced a situation where it was denied. As we know, and we can further discuss that later on, but although there may be issues, in general, that's doable here.
Okay, the owner, David, was right. It's all going wrong. The owner's family office calls you and goes, we are a bit tight, but we're selling some assets in the next few months. We're selling a business. Can we work with you?
The answer is always going to be maybe. So we take a look at all the pieces of the puzzle to see if it makes sense. And again, in this hypothetical scenario, it's a client that is a large client. It's a client that's been with us for many years. It's a multiple aircraft owning experience level. So we would want to at least open the door to consider working with them. And so once that door has been opened, we'll go down some paths. And the first path may be, what is the proposed solution? Does it make sense? Is this a short-term cash flow issue that they can solve by selling some assets? That checks a few boxes. Or is this more systemic? Is this a problem that exists in the entire organization and we don't see a way through this? Let's just part ways. And so we can go down a lot of different paths. We call it a tree scenario because there's a lot of different variables, but we'll go through those processes. We'll review the file, sometimes with the client, but most of the time we do an internal review with our credit division and our legal division. And so now we're starting to spend time and effort on this. And then we'll go through the possibility of issuing a formal notice of default. Just as a protective measure, as a legal measure, we may want to issue that. Even if we're being friendly and working through it, we still may issue that to give us more protections.
Well, I mean, it's interesting. Sometimes I think attorneys have to be, therapists with clients and tell them in the situation when it gets very bad or bad, do you love this client or you just like them? And if you just like them, you got to be a little more aggressive with the fix. And again, repossessions are awful. But once you go down that path, you have to be aggressive and go after them. And I would advise a bank, look, if you don't love them anymore, even though the relationship's great, cut them loose. And let's start firing on all cannons, figuring out what we're going to do, how we're going to do it, and timelines. You got to stick to them. But doing 3 and 4 forbearance agreements, it just kills me. It's great for the billable hours. But it just kills me because you just keep going and saying, look, this is serious. This asset's going to be diminished significantly if we don't act sooner.
So Ricardo, you're drafting an agreement. Do you check with his lawyer to see if they're still getting paid?
Yeah, I think that comes from the analysis of the financier. At the end of the day, whether overall, according to the historic payments and the relationship, if it's a case of being more aggressive or not. But legally, our recommendation would be, the first step, send a notice letter, a default notice letter. Because even if it's possible to renegotiate something, it's important to make a point very clearly. And if there's no payment, the alternative would be to move forward and repossess. One aspect I would like to mention is, at this stage, the cloud of insolvency would be closer, right? So maybe it is important to move forward and be more aggressive, because if there is an insolvency proceeding or a pre-insolvency proceeding, there is a risk of course issuing a stay order, which would prevent the creditor from terminating the agreement and repossessing the asset, the aircraft. And it's, although the Cape Town Convention is fully enforceable here in Brazil, and we have precedents enforcing the Cape Town Convention, there are provisions in the bankruptcy legislation and company reorganization law which would authorize a stay period up to 1 year, especially if the debtor is not an airline. If it's an airline, the protective is stronger, but if the debtor is not an airline, even if it's a chattel mortgage or a lease agreement, there are risks of a stay order if the aircraft is considered essential for the continuance of the business.
Okay, interesting. I didn't know that Cape Town exclusion was there.
Yeah, just one thing while we're at this stage, it can be really interesting to see what levels of solutions can come out when a client is in this particular early stage of default. Because there could be, again, with this scenario, there could be other assets that we can cross-tie that would help improve our position and allow us the ability to be more patient as they work through a workout.
Okay. You've negotiated. 3 months later, the family office goes, we haven't managed to sell it. We're going to be later. Trust us, but we need the aircraft. We're using it to negotiate, to sell. We can't give our aircraft back.
Well, this is the nuclear option here. So, Brazil is a Cape Town Convention country, but also IDERA is enforceable here. And if we had filed appropriate IDERA documentation under Cape Town, we may be able to issue a formal deregistration process without going through the courts. If that was not done correctly, or if we failed to file an IDERA, then we have to go through the courts, and that can be very lengthy and costly. And Ricardo would know a lot more about that, but and David would too. But what we try to avoid the courts as much as we can. So in this particular case, we would probably look for a voluntary surrender of the asset. Again, under this scenario, we're assuming good ties. They're falling under bad financial times for whatever reason. See if we can issue something friendly where maybe they do need an aircraft, but maybe they don't need that aircraft. So if they surrender the aircraft to us, maybe they have a 206 or something that they could use, or they could start to charter. We could introduce them to people here in the room that can have other solutions to the aircraft whole ownership. So that would be something that we would want to work with them on to try to get the asset back.
Well, indeed, because we are signatories of the Cape Town, it is possible, using the IDERA, to deregister the aircraft with the aircraft registry independently of any court order. So that could be a effective measure. But to actually repossess the aircraft, it would be necessary to file a repossession action in court. In our experience, of course, there may be delays, but we have succeeded in repossessing the aircraft based on the Cape Town and based it on local legislation as well, which is consistent with the Cape Town provisions. So that would be the way to go.
The owner's just not playing ball, so you're going to have to, you're going to have to repossess. You're going to have to go to the court. How long would you be telling Chris, or the mythical banker, to expect the process to take?
It's going to be a long time. I can't give a recent example, but again, I've heard of examples going back 30 years where it can take multiple years.
That depends on the type of the agreement. Long time ago, we have seen mortgage agreements where the creditor does not have the right to terminate and repossess, but the aircraft goes to an auction, so the creditor would receive payment after the auction. That would take years. But if the finance is structured based on a lease agreement or a chattel mortgage agreement or similar, according to local legislation, it is possible to terminate and immediately repossess based on an injunction. In our experience, it is possible to repossess within the time frame provided by the Cape Town Convention, which is of 10 days. So repossessing, 10 days would be the answer to your question, according to recent experience.
And this is why some banks prefer to finance in Brazil versus other countries in Latin America, because it is so well documented in law that there are rights that the lenders have in this country, and everything, if it goes smoothly, that's how it's supposed to work.
I remember this is a long, I never said, it's an ultra long range aircraft. I remember many years ago, pre-Cape Town, that when a Brazilian airline was late paying, the leasing companies were very happy to wait till it landed in England or the US and then park a truck behind it, and the passengers would be waiting, and then the check would come. Would you, Ricardo, you don't need to do that now. You wouldn't be suggesting if it flies to America, we seize it.
The question is in terms of a company reorganization or bankruptcy?
It's a bankruptcy, and the owner's flown it to Miami, or the owner's flown it to Vegas. Last switch of the dice, he's putting it all on red. Do you repossess in Vegas, or?
Well, I will answer based on the Brazilian legal perspective, okay, and assuming the aircrafts are here. Because if they are, it's another legislation, but here, we have had a recent situation involving Passaredo, which of Whyte. There was an initial order which determined a stay, so the creditors were unable to repossess. But the Court of Appeals of São Paulo reversed that order and applied and enforced the provisions of the Cape Town Convention. So I believe, and there is a trend, I would say, to enforce the Cape Town Convention. And there are provisions in the Brazilian bankruptcy law saying that lease agreements, whenever the lessee is an airline, the lessor would not be subject to the effects of the bankruptcy legislation. And so there could be no stay at all. Even the 30-day stay established by the Cape Town Convention, the 30 days, would not be applied because of the Brazilian specific provisions of the company reorganization and bankruptcy law. So I would say that the lessor would be protected, and that's the trend. Not that there couldn't be issues with an injunction from lower court, but at the end of the day, the Cape Town would be enforced and the local laws.
Yes, and I'll add, I'm sorry for bringing this up, but given the recent tariffs, if they were to fly it back into the US and leave it there, it would be subject to a 10% tax. So we may ask them to fly back to Brazil to repossess and remarket in the country.
There you go, tariffs again. You know, the whole process, once you start doing that repossession thing, it's tough. It's really tough. And, you know, I just tell clients it's the last resort. You've just got to figure out what you're going to do every step of the way. And, you know, once you have the plane, you have it. What are you going to do with it? Banks don't like planes. I mean, they like them to finance, but they don't want to operate them. They want to manage them, all that stuff. And so that's the risk, is once you get it back, like the dog chasing the truck, you caught it. Now what do you do with it? But you have to do something, and it all depends on the facts and circumstances. But there's a lot of nuances in the states that are great for lendors and lessors. You have Section 110 of the Bankruptcy Code that gives them protections, gives them the opportunity to seize it. You can do self-help, which is kind of risky, but you know, there are a lot of options that once you're talking about those options, it's kind of depressing.
But Chris, you're as relaxed if you're doing it in Brazil. Not that you're relaxed, but Brazil, the US, you don't really have any major stresses.
No, I mean, we love Brazil, and we want to continue to improve our relationship and our portfolio here. And so we've been working here since 1996 in various capacities. And but I would say from a general banking perspective, the country is very sound. It's growing, it has the rule of law. I would say these are all things that are very important for banks to lend.
There is a great story about an Indian registered aircraft that the tax authority took a lien on, and I think it was 8 years in a Biggin Hill hangar, falling apart. Okay. A question from the audience. During the repossession process, who is responsible for aircraft maintenance reservation?
Yeah, go ahead, Dave.
Well, I mean, that's a good question, and that's why I said repossessions are ugly. So if you repossess an aircraft and do a public sale or something, and you don't take care of it, you could be sued by the person who didn't pay, the borrower. I'm like, what the hell? He didn't pay anything or she didn't pay anything, and now you're suing us because we didn't take care of the plane? Come on. But that's the risk, and I tell banks, you might get sued. What? They know that, but I mean, that's the risk, is that you're responsible.
There is a feeling amongst the operator community that they often come out second best in this situation.
I mean, you have tripartite agreements, so I mean, they signed them. You know, you can pull the agreement out and look, that's your signature. I know you agreed to do this 4 years ago or 2 years ago, but the managers should have responsibility. The operators should have responsibility in this process.
Thoughts on the operator tripartite, Ricardo?
Well, I think I don't have any further comments about any addition to what David mentioned. Chris, please, if you have some comments.
No, I don't have any more.
Not even as a hypothetical, Chris.
No.
Any questions from the audience? Yeah, coming to you.
Or actually, a follow-up comment to what David said. You had a case in Curacao where there was an embargo placed on the aircraft, and it got ugly, it got messy, like David mentioned. But there were injunctions flying, all over the place, left side, right side. But one of the injunctions that was issued against the person embargoing the plane was an order for them to maintain the aircraft, or rather keep it in a preservation program while it remained under that arrest. So there wasn't just any discussion. There was a court order there, and subject to penalties. So you better be sure you do the job right, because if not, he didn't pay, but you have an exposure.
Yeah.
Still got to do it.
Yeah, that's the way it should go, and we count on that.
Okay, I just want to get back what David said. It was driving attention when you said it's an ugly, repossession is an ugly deal. I know that I suffered this kind of things sometimes in the past, but let me ask you this. After the Cape Town Convention, when you do the IDERA immediately, I think, but I would like to have your impression. Best thing to do is take the aircraft out of Brazil at once. Otherwise, who is going to do maintenance in the aircraft, like you asked? And under what C of A? I mean, there is no export certificate of airworthiness issued for this aircraft. So it's a huge question. You are deregistration the aircraft at once. So it's an UFO. It's not Brazilian, it's not American, it's not European. Mm-hmm. So what is your impression? How you deal after the idea, if you have to stay like 1 month, 2 months to take off the aircraft? How do you have this idea? How do you?
Well, go.
So that's a good question, and care, custody, and control of the aircraft is really important. And yes, repossessions can be confusing or ugly, but they also can be handled in a way that both parties are amicable. And this is always the effort that both parties should strive for. It's more fun when things are going wrong for both parties to agree on a solution than it is for parties to fight. It's also less expensive for both parties. So in this case that you mentioned, it's a good example where we have an aircraft that is going to go through the IDERA. So it's assuming that it's going to be deregistered and then exported, we want to make sure that the care, custody, and control is in a secure area. So we would go to a trusted friend that we have in country, make sure the aircraft is locked up in a secure hangar, and try to minimize the chance of something happening to the aircraft while it's going through that process.
I'll just add too, you got to be careful of the unknowns, right? You know, Maduro's planes are all seized by the U.S. government. Abramovich's planes are seized or under warrants. There's risks out there that you just don't know. And if you can maintain a friendly relationship in accordance with the law, that's the best thing to do, you know.
Yeah, and depending on the regime of import, it's necessary to comply with customs requirements for export as well. So when you mentioned just taking the aircraft out of Brazil, that could bring issues in terms of the legal situation of the aircraft. If it's not properly clear, the export is not properly registered and clear with customs. So that's an issue to be resolved, and there are ways of doing that, even if there is a repossession action.
And I'll point out further, too, to your example, if the lending institution does decide to go through that process through IDERA and deregister and then export, say, back to the United States, for whatever reason, maintenance or for resale, tariffs. So is the lending institution going to kick, we're talking about a super mid-size aircraft, is the lending institution going to want to put up a bond or pay the full tariff of 10% of the value of the aircraft? This is another expense. It can determine the country of repossession and remarketing. It's very likely that the lending institution would not want to go through that if they can remarket the aircraft here in Brazil.
Okay, let's not end with a sad story. The guy sells his company. He's put his money on red. It's come up red in Vegas. He's cash rich. He calls you and says, I want to bet a G650, G700. Do you take his call?
Well, we'll take the call, but we'll probably introduce him to our friends at JP Morgan. Wait, no, I'm joking. But so gambling income is not something we put a lot of effort and trust behind as a recurring revenue source at most lending institutions.
And then he says, can I pay you in Bitcoin?
What we would likely say is, you've done so well in Vegas. Why don't you pay us off, and then we'll invite you over for dinner sometime. But I think that would probably be the end of the relationship.
That was a fairly happy story. Thank you very much. Thank you.
Thank you.